Thank you for all rising. Please join me in the Pledge of Allegiance. I pledge
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
All right, please be seated. This is a continuation of a hearing that was begun at the regular February hearing, and it's two cases with the same respondent. It's case number ENF 2023-110163, which had already begun, and then case number ENF 2024-010059. The respondent is Capital C, Inc., and note for the record that Mr. Crowley is here on behalf of the corporation. And also that the violations are identical. It's two contiguous parcels of property as the evidence showed in case number, I'll just call it 163. That's the ending numbers of it. And so I think, if I remember correctly, we had almost concluded, if not concluded, the 163.
We were close to
hearing.
the end, but since the
Okay.
continuation, there was supplemental, as the court directed, if you wanted to.
Yes.
So there is supplemental evidence and testimony in that case to now present.
Okay, and let me just note for the record, too, that I received from the county a memorandum of law as requested on the 8th of, on or before the 8th of March, and that will be entered into the record as well, along with a witness list and petitioner's witness list naming 5 county staff members, and then petitioner's supplemental offer of proof in both cases 059 and 163. So I have the 163 supplemental offer of proof. It's long, and I don't know that every bit of it is required, but I guess we'll see where the evidence leads. So let me just swear in the witnesses. If you'll raise your right hands, do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, and I see Mr. Counselor, Mr. Schilling. What have you got for me?
I need to begin with an application, Your Honor.
Okay.
Concerning exhibit number 15, in this case 163, that was entered into evidence, that was a clerical error. It's an affidavit of posting the wrong case. It was an affidavit from a different case that was actually entered into evidence. So I would request the court now, at this point, strike exhibit 15 that's previously entered.
All right, may I see it, please? Yes, it is, an entirely different case. All right, that exhibit is stricken. All right, anything else?
You know, at this time, I turn it over to Officer Counselor to continue with picking up where we left off at exhibit 33 was the last one entered into evidence.
Okay.
Okay, so this case was continued from the special magistrate held on February 21st, 2024. So since that, to replace Exhibit 15, Exhibit 34 is the correct affidavit of posting for when I posted the property. And then going forward, on March 6, 2024, a meeting was held with the respondent with
Hang on
code.
just a second.
Okay.
All right. Okay. All right, I'll deal with that in a little bit.
Okay.
Go ahead.
Okay. On March 6, 2024, a meeting was held with the respondent, code enforcement, the building official, and the growth management director. A stipulation agreement was offered, but agreement could not be met. At the February hearing, Exhibit 15 showed the wrong posting affidavit, and the correct one is printed as County Exhibit 34. Exhibit 35 is an aerial photo showing the condition of the property prior to the 2022 purchase of the property. And this is basically showing that it's a vacant, unimproved lot.
Okay.
Exhibits 36, 37, 38, and 39 are photos dated from March 1st, March 4th, and March 5th showing RVs remain on the vacant, unimproved lot, some for multiple days. So,
Okay, so this was subsequent to the hearing, just prior to today's hearing.
right, this is all new evidence. So Exhibit 36, March 1st, basically focus your attention on the gray school bus RV parked there. Another Exhibit 37. This would be from March 4th. School bus is there, RV still there with some campers. Exhibit 38, showing 2 campers, people got chairs set up. RV still there. That's March 4th. March 5th. Still there. And then Exhibit 40 and 41, that's Exhibit 39. And then Exhibit 40 and 41 are emails from the respondent discussing violations and reviews from campers that have camped on the property on the vacant unimproved lot. So Exit 40 was, basically this is correspondence from Mr. Crowley to the county.
Okay, if you'll just roll that up a little bit. Oop. Okay.
It's a couple pages.
All right.
This was basically just trying to set up a meeting.
All right, this was all in the supplemental material sent to me, right?
Correct.
Yes,
I've seen this before, so.
Okay.
All right.
And then this is basically an email that he sent us basically from a review that he received for people who had camped on the property.
Yes.
Okay,
Yeah, I also read that
okay.
before.
And then Exhibit 41 is the final email and our final exhibit. I request that these additional exhibits be received in evidence. Based upon the testimony and evidence, I request that the respondent, Capital C, Inc., be given a no-repeat order.
All right, if I can just break in, we have a little bit more, Chris, so
Okay.
we'll do that. We'll do the final wrap-up at the end.
Okay.
Right. Okay. Who else?
I have Paul Schilling.
All right, Mr. Schilling, good morning.
But if I could suggest, can we move the supplemental exhibits into evidence first before I?
All right. Let me ask Mr. Crowley, any objection to the,
He's-
I have to swear you in. Let me just raise your right hand. Do you swear or affirm testimony about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right. And you've seen exhibits 34 through 41. Any objection?
There are many photos in that, there's many objections, but I don't dispute the facts, and I think you understand the facts. So I don't think it's going to make a difference.
Well, If there were a legal objection, I would entertain it, but hearing none, I will accept into evidence the county's exhibits 34 through 41. Okay. Mr. Schilling,
Morning, Your Honor.
good morning. What you got for me?
I have some good. The first thing I'd like to do is ask Mr. Schilling some questions about his background. So I believe you had previously testified, Mr. Schilling, that your current position is Growth Management Director for Martin County.
Yes, that's correct.
And how long have you held that position?
Since approximately May of 2020,
Okay. And prior to that, what position did, let me back up. How long have you been employed by Martin County?
just over 17 years.
And has it all been in the Growth Management Department?
Yes, it has.
Okay. So prior to your position as Growth Management Director, what was your position?
I held several positions through my tenure here. Going backwards from our current position, Deputy Director,
Deputy Growth Management Director.
Deputy Growth Management Director, Development Review Administrator, Principal Planner, Senior Planner, Zoning Compliance Technician.
Okay. And prior to your employment with Martin County, were you employed in a private corporate thing in the growth management, growth development field?
Yes, I was employed by a surveying and mapping firm in south of here. And part of my,
Well, how long was that employment?
approximately 8 years.
So, so basically, do you remember when you started with that, what year?
I had some information here, bear with me. It would have been 8 years prior to 2006.
So 1998.
Correct.
So since 1998 to the present, you've been continuously employed in the development and administration of growth management.
Yes.
At this time, Your Honor, I'd ask the court to qualify this witness as an expert in the field of land development regulations.
Okay, any objection to that?
I have an objection because he's the plaintiff and he wants to claim as being the witness. If he had somebody independent from that, I would accept that.
Okay, then let me just clarify. The plaintiff, of course, is Martin County in this case. He is an employee of Martin County, but I can tell you just based on personal knowledge, his background qualifies him as an expert. The difference and the significance to you is that enables him to offer opinion testimony. So he can give you an opinion or give the hearing an opinion, but it's an opinion perhaps. He can also, of course, testify to facts, but that would be the witness for any county employee.
So the only thing you're benefiting by making him an expert witness
Yes.
is his biased opinion, because so the way this works is Don Donaldson gets to decide which of these gets done through their agents. And Mr. Schilling is his primary agent in the growth management. So the opinion of the county is expressed through Mr. Schilling. And so he can't be an expert witness who offered unbiased opinions while being in a biased role.
Yes, actually, he can.
I know, but I'm making the point that even at the last meeting when we were talking about his terminology, for example, when it came to, I asked him, for example, has there ever been a parking lot created in Martin County?
Objection, Your Honor. The respondents,
I'm hearing argument. It's okay.
the respondent should be limited to voir dire on the witness's qualifications.
All right.
I'm saying, even at the last hearing, I asked, has the county ever created a parking lot? And he said maybe instead of no. That's the bias I'm talking about.
All right.
Knows the answer, he doesn't know.
All right, it's up to me to figure out the difference. I can't rely on that expert testimony necessarily.
I would submit to any expert with his qualifications in an independent role.
Yeah, and actually, I'm going to find that he is an expert just based on my personal knowledge of Mr. Schilling for since 2004, anyway.
I said
So-
he is an expert.
Okay.
in another case, he would be appropriate,
Right.
not in a case he's pressing against.
That also enables the attorney to ask questions that are somewhat leading. You'll be able to respond, you'll be able to ask questions as well. Okay, go ahead. And Mr.
you,
Schilling,
Your
you are qualified as an expert.
Okay. Mr. Chilling, are you familiar with the subject property that we have?
Yes,
Okay. And is the subject property currently vacant land?
yes,
Okay. Would the parking of vehicles on any kind on vacant land constitute a modification of the land?
yes,
And such modification would then require a development order before such use would be used, correct?
yes, that's correct.
Okay. Is there any, to your knowledge, has any development order ever been issued for either of the subject parcels of land, this case or, well, just for this case?
No, sir.
Okay. To your knowledge, has an application for a development order ever been received for this parcel of land?
Not a development application. On the one portion, we have had a pre-application. But that is not a development application. That is simply a conceptual plan,
Okay.
unrelated to this case.
Okay. Can you tell the court what the definition in the county ordinances, Article 12, is a parking lot?
Would you like me to read it if I can find it here real quick?
Okay, well, let me read it to you and tell me if that is correct. Is a parking lot, as defined in Article 12, a principal use of land for the purpose of providing short-term parking of operable motor vehicles to support nearby land uses?
According to Article 12, yes.
Okay. You're familiar with the use of the property that was being made during this case, correct?
Correct.
Okay. Is that parking, in your opinion, related to any nearby land use?
No, sir.
Okay. Going back to the classification of the property as vacant land, is an accessory use allowed on vacant property?
No, sir. Accessory use requires a primary use.
Okay. And is the parking of recreational vehicles, boat trailers, and similar articles prohibited as an accessory use in the Port Solano CRA?
Yes.
And by the parking of such vehicles on vacant land?
Could I clarify?
Yes.
For example, if someone were to have a residence, something of that nature, yes, then those accessory uses would be appropriate.
Okay. So let's explore this, the concept of a primary use. A primary use means then, in your opinion, there is some other structure or use of the property existing beforehand.
Correct.
And that's what allows you to then park and use something, not just, it doesn't just apply to vehicles, it's structures and other things that are deemed accessory. There must be some other primary use in place first.
That's correct. The accessory uses are dependent and in conjunction and associated with the primary use. For example, a residence with a guest house, a residence with a boat dock, a commercial business with an outbuilding, ancillary to the primary building, parking expansions, things of that nature.
So then, in your opinion, as the, growth management director, if a person wanted to just park vehicles on a piece of land, it would require a development order because that would be the primary use of the land.
Correct.
Yes. And without a development order, no such parking would be allowed.
That's correct.
No further questions for this witness.
All right. Mr. Crowley, do you have questions for Mr. Schilling?
Yes. You may need to do it for him. Would you please read the definition of parking lot again?
Sure. Pursuant to Article 12, Section 12.1.04, parking lot a parking lot is a parking lot or structure operated as a principal use for the providing of short-term parking of operable motor vehicles to support nearby land uses.
And your point to Mr. Schilling was, your question was, does this lot support any nearby land uses? And his answer was,
Objection, I did not ask if this lot supports any nearby land uses.
that's why you were trying to define that this wasn't a parking lot. You were trying to exclude this as a parking lot. If you want to,
Let me just tell you and caution you. You can't just have a conversation with him and you can't argue with him. You can ask questions and elicit.
I'm not a lawyer, actually.
I know.
Have a little bit of room, please.
Yeah, and I've tried to give you
I
as
know.
much room,
I'm learning as I go.
probably more than I should have.
Than I deserve. I'll ask the question. I understand your point.
Let me try and ask that question because I'm curious about it as well. Let me see if I understand correctly what you've said. And I was also looking at the definition of parking lot, and there's a definition of parking lots and garages in 3.3, the glossary of terms for the entire land development code. It's slightly different than the one that's in 12, but I'll read that to you just to refresh your memory. It says, parking lots and garages, a public or private parking lot or parking structure operated as a principal use for the purpose of providing off-street parking or storage of operable motor vehicles, including trailers, but specifically excluding the parking or storage of construction equipment. So, sounds like you can park anything except for construction equipment on a primary use, principal use is how it actually calls it, parking lot. Is that correct?
That's correct.
And does that require a development order?
Yes.
Okay. That's all I wanted to know. Okay, you may have
Has
other
the county
questions.
ever issued a development order for a parking lot? Mr. Schilling?
For a standalone parking lot, I'm not aware of one.
I had the same question at the last hearing. and
I remember you asking.
I would have thought by now that we would have the answer for,
I
he is
just,
an expert.
I just answered the question.
No, it's, what he's saying is no.
Okay, well,
To his knowledge, no.
okay, so I'd like to enter this into evidence. This is a building application.
Your Honor, this is not the,
I'm asking him a question. If this is his department, building application,
It-
development reviews.
Is that something that you have already submitted to the department?
This is from the department. This is from the building department. So let me ask.
Record.
Yeah, it's to his expert opinion about whether the county has, so not only is it his expert opinion, it's his job to issue all of these
Does it have
development orders.
anything to do with this?
Here's my point. I went to the building department and asked to give me all of the development order reviews for parking lots in Martin County. And the only one that they had was this one, which was for a temporary parking lot for a sales building for Banyan Creek, I think. So I submitted this into evidence as the county has never, because I went and did the research, issued a development order for a standalone parking lot.
The county stipulates to that. They agree.
They have, no, he said maybe.
No, I said no.
The county has never, okay.
They said to his knowledge, no. So,
Right. And I would also submit that I have submitted to the code. I have so much paperwork here, sorry about that. Oh, these. So not only have they not ever issued a development order, has the county, I guess I have to put this as a question. Has the county ever initiated a code violation for parking on a legal commercial lot for not having a development order?
Legal or illegal?
No, an illegal lot would be a residential lot, et cetera. I'm saying, has the county ever initiated a code enforcement hearing for the lack of a development order for cars parked on a permitted use property, a commercial property? Has the county ever pressed this argument that a development order is required? Because under oath, you said that if cars park on an empty lot, then they need a development order. And I'm saying, has the county ever prosecuted that?
I can't, excuse me, I can't answer that definitively. People park vehicles in a lot of places, and I'm not sure at times, for example, in the right-of-ways, whatever the case is, if there's a development order, or a previous approval, or a existing parking lot associated with a restaurant or something, then of course we wouldn't prosecute that unless the vehicles were abandoned.
I'd like to submit into evidence, on March 1st of 2024, I did a code complaint.
Your Honor, once again, objection. It's not to respond to this point. He's not presenting his case in chief. He's just supposed to be cross-examining a witness. It's not the time to present evidence.
You read definitions to the expert witness. I'm reading stuff to him too.
Yeah, but if
Point-
you get it, you're going to get an opportunity to do that. This is like cross-examination, if you've, you
I was
know,
making the points, so we were making the points about parking, and he said in his expert testimony that if I'm parking on a property, I have a permitted use to park my cars, but if I do, then I'm in violation of not having a development order. And I dispute his testimony on that.
okay.
Because there's never been a prosecution, he's never prosecuted this case against anybody, and they don't exist. Martin County's never created a parking lot.
But you're going to get a chance to argue that?
Okay, well, I'm just
What-
arguing, I'll argue my point, but I'm arguing against his expert testimony. I can move to the next point.
What, yeah, ask a question.
Okay.
Or sit down.
Is there any primary use on my property?
Of the two properties that are subject to the violation, no.
Has there ever been any development order issued on my property?
Not that I'm aware of, no.
Would a development order be required in order to have an accessory use?
Yes.
That's important, Your Honor, because one of the codes that they use says accessory uses are not permitted to have overnight RV parking.
Correct.
So the fact that I can't have an accessory use because I have no primary use, that section of their whole argument falls apart. That's why it's important that we've established these facts.
No, I disagree, but because I've now read the code in the last couple of weeks, so you go ahead and ask your questions.
What my question was, is if I don't have a primary use, can I have an accessory use? And he agreed that I cannot have an
Cannot.
accessory use. So therefore, when we get to that argument, I don't want that to be, there cannot be an accessory use because there is not a primary use. That's a very important point. We'll make that point later when I make my argument. I'm trying to differentiate, hit the questions from.
Okay, but what you're going to learn is that recreational vehicle parks as a primary use are not permitted in the
Yeah, I accept that.
Salerno.
I accept that.
Okay.
And if you accept, if you say to me right now that do you accept the county's argument that I am operating in a recreational vehicle park, this whole thing, I would comply because of course it's illegal. Of course a recreational vehicle park is illegal.
Okay. Now,
But I mean, but my argument is I'm not doing one because I read the definition. So I was going to ask the next question is by definition, am I a recreational vehicle park? When you read the definition, it says I must charge.
yeah.
And I can't understand how unclear that is. And the fact that it's free, I can't see how I fit into the category. Mr. Schilling and his expert testimony and his intent, I understand clearly. They wrote the code and they said, I don't want a recreational vehicle park. I can't understand intent. I just have to read the law. And when I read the rules, I said, if I do this and don't charge, since I don't have a primary use, I can't be an accessory use. I'm not a recreational vehicle park because I'm not charging. If I charge $1, boom, I'm done. I'm out of here. I'm illegal. But because I'm not charging. Anyway, I'm trying to ask a question instead of give my case. Thank you for giving me some.
Go ahead.
Anyway, to my further point is, these are a series of code complaints for this very issue. Does parking on a vacant commercial property require a development order? And there's been no action from the code enforcement on these issues.
Do you want to show those to Mr. Schilling and ask
Well,
questions
Mr.
about them, or what do you want to do?
I guess it's his department, so I guess John can answer the questions. I don't know how this whole thing works as an expert.
Well, I would like to review, if we're going to be accepting evidence now, I'd like to review it first.
I
My point is, these are code cases I opened that are for the exact same issue I'm using my lot for. The court of this case, Your Honor, is that what I put? Your Honor.
Close enough.
The core of this case is whether I need a development order to park cars. That's what this whole thing rests upon. And that's what these issues are for, is I can open 1,000 of these all over Martin County and get zero compliance.
Okay, again, that's argument, but
Your Honor, may I just make a,
make sure Mr. Tui can see what.
Before anybody says anything.
I'm not discussing these today, I don't think. But my point is that there's a clear distinction between, and what we're talking about today is parking vehicles on sites as opposed to running and maintaining RVs and campers.
I agree with that.
Okay, so I just want to make that clarification. There are people perhaps parking in places they shouldn't be, perhaps off of parking lots in conjunction with other uses, primary uses. For example, if a restaurant expands into an area potentially without a development order, a church may have grass parking that's not officially part of a development order, but it's ancillary and accessory to the house of worship. So we have those throughout the county. In a variety of circumstances, they predate the code, in fact. So we need to keep all this in mind today, I think, would be helpful.
Here's the question. If I didn't have RVs parked, if I just had cars parked, would we be here today? Would you have pressed this case?
Yes, it would be a parking lot without a development order.
So when Ranger Construction rented my property on behalf of the county to store construction equipment on my property, which I have leases for here, yeah, I mean, which you're very well aware of because you were part of the project, that was okay. But I can't park cars there.
A temporary use, first of all, I wasn't necessarily involved in that. I'm aware that there were some temporary uses with respect to, I think, asphalt millings and equipment as part of a public works project for repaving, resurfacing of a roadway. But that doesn't negate the fact that a development order is required for a permanent operation, even temporary.
I'll make the point I would like to answer is because the thing is, we're here because of the RVs. I accept that. I want the expert witness to say that's why we're here. And I want the expert witness to admit that if I was using this for anything else, which I've been using, and everybody else is using, everybody wants them to use, parking cars, that we wouldn't be here. That This is whole and part about RVs. And
Asked and answered, Your Honor. The witness just testified we would be here.
Yeah, and that's correct. What Mr. Tui is saying is absolutely right. Mr. Schilling,
I did answer it. I know, but I'm making the point that
you're jumping ahead. Any more questions for Mr. Schilling? Okay, go ahead and have a seat. All right, anything else? Yes, let me just see what,
And now that I've seen it, I would enter an objection that I'd say relevant. None of them have anything to do with the subject parcel. That's the subject of this case.
five, okay. These are records from Martin County. They are 5 pages of, I don't know exactly how you would call them, but they indicate that there are at least 5 situations where people have used.
If I could clarify a little bit, Your Honor, they're called requests for services. They're the record of the online complaint system. Any citizen, when they believe there's a violation, can report it, and that's the form that it reaches the Code Enforcement Division.
Okay. So these are, nothing's been adjudicated here. This is just a citizen complaint.
The citizen of an alleged violation.
And I agree. These are not relevant, and I'm not going to entertain them. Okay. Yeah, it would have been different had they been actual cases opened by the county. All right. Hang on. Too early.
that's the point. They haven't been open.
Okay, and you'll argue that. Anything else, Mr. Schilling?
Not at this time, thank you, Your Honor.
Any further witnesses?
No, no further witnesses, Your Honor. I would turn it back over to Officer Counselor to wrap up the county's case.
Go ahead.
Based upon the testimony and evidence, I request that the respondent, Capital C, Inc., be given a no-repeat order, as the violations have been corrected before today's hearing, but not before the initial compliance date in the notice of violation. The county's incurred the cost of, in the amount of $575 conducting this investigation, and request that the county be reimbursed this amount at the conclusion of today's hearing. And that
Okay.
concludes my testimony.
That's the first testimony that I've heard that Mr. Crowley is in compliance.
Yes. Basically, March 7th was the last day I witnessed RVs being parked on the lot.
Okay?
As of yesterday, I can submit this picture.
Your Honor, if I may,
Go that to Mr. Crowley first.
that's my oversight, Your Honor. I was going to ask the question and establish that, but the distractions, I lost my place and I forgot to ask the question of this
Okay.
witness.
Okay, just, may I see this? Looks like a vacant lot.
Vacant commercial lot.
Okay,
So basically, what the county is requesting is a no-repeat order. Basically, since the respondent didn't meet the request to comply the violations by the violation letter, but he did comply with the violations prior to today's hearing, we're just asking that in order to not repeat the violation, be ordered against the property.
and is this just as to
That's just
the lot in case number 163?
correct. I have a separate picture for the other case.
All right, any objection to this photo?
Not to the photo, no.
All right, I'm going to accept it as exhibit number 42, which I'm going to mark on the back for whoever's recording, okay?
Thank you, Your Honor.
All right,
That actually has been entered as Exhibit 35.
this one has?
Yes. No, oh, no, I'm sorry. Once again, I've gotten, yeah, that was our aerial view of it vacant. This is the latest view. I'm sorry.
Okay,
Withdrawn.
it's there, 42. All right, well, wow. I don't need to hear, I don't need to hear argument as to whether or not you're currently in violation.
Well, I am in violation. There's cars parked there now. This just happened to be a few days where there weren't cars parked.
All right,
And I understand your point about their point, but I want to have a decision on this case. I don't want to,
you're going to get a decision on the case. No.
well, I mean, I want to be able to argue. What they're doing now is they're saying, he's not in violation, here's my recommendation that nullifies the whole case, and I don't get to argue the case. And I'm saying, I'm in violation. And that's not true. I don't accept their evidence. I haven't, just a few people haven't parked there in a few days, and they had 25 days of evidence, and 3 days says that I'm not using it.
So, let me just take a look.
If I might direct the court's attention to Exhibit 12, which is the amended notice of violation, which provides the compliance date.
All right.
A defendant insisting
Okay.
he's guilty.
Yeah, I don't think there, yeah, I had read that before. Thank you. All right. Okay. So essentially, the county has rested its case on 163. So, Mr. Crowley, what do you got to tell me?
So much. I'd like to make a motion to dismiss based on so many things. And I would just ask, since you've been very gracious with me in terms of my lack of understanding of the process, that if you do disagree with the dismissal, that you give me some, I have a lot of paperwork and a lot of history with this property. If you can give me some guidance in terms of how to argue to you, I guess, this would be the question. I don't know, like, because there's 3 sections. If I say, I motion to dismiss, and you say, Mr. Crowley, I deny your motion. But you agree with one of the 3 or 2 of the 3 points. That would be helpful.
Okay. Tell me the basis for your motion.
Okay, the basis for my motion is I have no primary use, therefore I cannot have an accessory use, and therefore the 3rd violation can't apply, that whole section. It says 4 accessory uses. And we can read the definition of accessory use, but under oath, Mr. Toomey asked Paul Schilling what an accessory use was, and he said you needed to have a primary use. Under oath, Mr. Schilling said, I do not have a primary use. I've also have evidence here, which I'll submit, that Lisa Weschler from the engineering department says that I don't have a primary use, and Elise Elder, the assistant county attorney, also says I don't have a primary use. Because I applied for permits for having a temporary parking lot, and they said that I can't have a temporary parking lot because the definition precludes primary use. Therefore, that 3rd section is just totally garbage. I don't even apply. Their point earlier was, as an accessory, if I was an accessory use, I could park cars there legally. That's true. But as an accessory use, I could not have them sleep overnight. And so,
You know, let me tell you, when I read through the materials and read your argument, which you offered in writing,
yes,
and which I accepted as an exhibit.
Yes.
So I fully considered that. One of the difficulties that I see with the county's case is in that accessory use section. I don't think I need to get that far. This is the long way of telling you I am going to deny your motion to dismiss. But I think it's more simple than you've made it.
I'm certain it is.
All right, and the first thing is, can you use vacant property without a development order? Do you need a development order to use your vacant property? And as you pointed out, it is a commercial parcel. And I think the answer to that is yes, you must have a development order to use your property for any kind of commercial use. Okay, and parking is a commercial use. In this particular case, in this particular instance, it is. The second thing is, if you were going to allow RVs to park there, you couldn't get a permit to do that because it's not a permitted use. And so what you've got is this dichotomy between, I've got this piece of vacant land, I now invite RVs to come and park there, and I don't have a permit either for a parking lot or for an RV parking park, because I can't get one of those.
That's right.
But I can't park anything there because even though that's a primary use, I don't have a permit to do it. And if you had a permit, presumably you would have to build it as a parking lot. You'd have to pave it, you'd have to landscape it, you'd have to light it, you'd have to do all of the things that people do when they own parking lots. But you haven't done that. You just have this vacant piece of dirt that's got a fire pit and a couple other little things on it. But you have started to develop it, and you've asked people to come use it.
Yes.
Cannot do that without a permit.
Well, I'm saying that there is no such permit.
Well, there would be, but you haven't applied for
I
it.
have gone and applied for permits. I've applied for a parking permit and a temporary parking permit. And the documents I gave you from Elise Elder and from the county attorney said that I couldn't get a temporary parking permit. And the reason I applied for a temporary parking permit was because I don't need to go through the whole development order process. They can give me something temporary. I was like, this is great. I read the whole code 16,000 times, and I finally found a solution. I can have a temporary parking permit. Because with a temporary parking permit, I don't need a development order, I don't need all these other things.
Okay, but you still have to apply for and obtain it.
But I can't, and in those letters, they said I cannot apply for it because I don't have a primary use.
No, there is in the Salerno district, a permitted use is a parking lot.
That's correct. I'm glad you read that. I brought that with me, but I won't have to put that in there. It is. But now that it's permitted, if you look at the list of permitted uses, it says church, restaurants, all the kinds of different things. All of those and all of the code that Mr. Schilling has written is about doing something, building things, and I understand all of that. I am just, that parking is the only thing permitted that hasn't been thought through by the county. And it hasn't been thought through because they've never done it. Stewart's brought a lot of parking lots, and that's what this whole argument's about. I don't think you understand that, or maybe you do, that I'm a public figure in Port Salerno. I've been in TC Palm, I've been in WPTV, I'm all over Facebook.
And I
My argument-
apologize,
my argument is this
I'm
is
not
a
aware of
political
that,
issue.
but.
My argument is this is entirely a political issue. And because there is no parking permit, I never had a problem parking there when Ranger Construction was parking their trucks on behalf of the county. When I had car shows, just like all the other things that go on in Martin County, the fishermen park their boats. Twisted Tuna has a lot that does not have a development permit. I could go on and have 1,000 of these that don't have development permits. The only reason that we're here today is because of me being a public figure and having a lot of complaints.
All right, I'm not aware of that issue, that you are a political figure and a public figure, but
have
that's
the articles
my
with
fault,
evidence.
I'm sure. Anyway, that's not relevant to the issue that's in front of me. I'm being handed documents. What is,
This is for the evidence. These are the printed news articles about the Salerno opposing parking because Martin County is renowned for tying themselves to trees in order to stop development.
again, that's political, and I mean, you're talking to the wrong person as far as
I'm
that's.
trying to make a legal point, but there's a political aspect to this as well because I wouldn't be here at all. Like, I'm the first person in the history of Martin County that's being prosecuted for having cars on a permitted use. That's my entire point.
That I didn't see yet, Your Honor.
Okay, and I don't even know what that is, but.
And these articles I would object to as being irrelevant to the case at point, that
I think
there's been no,
Mr. Schilling has been presented as an expert. I'd like to qualify myself as an expert and submit these articles as evidence to my ability to create passion at the very least.
Yeah, this really has,
If you deny it, though, I can't use it in an appeal.
but it almost has no evidentiary value.
so
It goes towards the fact that here's the point. We're arguing the legal points that they've made. Their points are complicated. Mr. Tooley's complaint against me, the memorandum of law is 40 pages. There's 1, 2, 3, 4, 5, 6, 7, 8, 9 people out here, opposed to me. Their evidence is muddled and full of mistakes, and they had to take out different things. It's just me up here against them. And it's never been anybody else except for me because there's a political issue behind all of this. And I'm saying that I'm going to argue the points, and I'm trying to make the points about the definitions. But I want everyone to understand, I expect the county to open 1,000 cases the same way. You can't complain about my lawn and not enforce the neighbor's lawn.
Well, actually, they can do that as well, but you realize that my job is to cut through all of that.
I'm not talking to
And to
you, I'm
get
talking
it
to the
as-
appellate court.
Simple as possible.
I understand, and I don't expect
I'm
in
going
this
to,
case.
I'm going to deny your motion to bring that into evidence. Those are not, they're anecdotal, there's no way to authenticate them. I mean, if Mr. Fortnoy was here, you might be able to bring them in, but I just don't see how that's possible.
No,
As-
not
as
the
the-
evidence you denied.
As to those two, Your Honor, County has no objection whatsoever then going to evidence as a statement against interests, considering they established the county's case.
All right, this is a letter or an email from Lisa Wixer. Subject is the coffee shop, August 4th, 2023. You're submitting that.
Yes.
Okay, and it's a copy of a county record. Okay. So she's discussing the opportunity to resurface and restripe Southeast Salerno Road and two people's capital project administrator. Okay, we did something similar around 2015 when an on-street parking was added along Southeast Commerce between Salerno and Seward. After further review of the land development regulations, I don't believe the vacant site will be eligible for a temporary parking lot. Land development regulations require the county engineer to determine that off-street parking requirements of the primary use cannot be met and that the primary use meets all other requirements of the land development regulation code and comprehensive plan. Since the site is vacant and there is not a primary use on the site, I cannot determine that the parking requirements she says cannot be met, but could be, I think is what she meant. And signed Lisa Wixer. And then there's a slightly earlier, July 25th, 2023, email from Elise Elder, Assistant County Attorney, regarding the Salerno Coffee Shop pre-application meeting. It has to have an independent primary use to utilize the temporary parking provision. Signed, Elise. Okay.
So the reason for the,
You're moving these into evidence. The county has no objection. I'm going to accept them into evidence as Exhibits 2 and 3. I think we have one of yours.
so my point about this is for more than a year, I've been trying to use my property. And I've been to growth management many times, and I've talked to Clyde Dolan and talked to Paul. And I've been, shut down every time. I thought the temporary parking thing was going to be great. But the county assistant attorney and the county engineer said that I needed the primary use. We've established that I don't have any primary use. To my point earlier about if I don't have a primary use, then all of that accessory use is garbage.
All right.
My point is, then I went and said, okay, let me build an actual parking lot. And the difference was if I started putting millings down and I started doing creations, the engineer said yes at that point. For example, when Ranger Construction was using my property on behalf of the county, they parked their equipment, they had porta potties on the property. Not without a development order. Paul's going to argue that it was a temporary use. That's not in the code. They just did what they wanted to do. I wanted to put millings down when they were finished because they were doing the surfacing of the roads. So I had a long conversation with the county. I said, what's the difference between, because I didn't want to have to go through the development order process because I'm going to be building big buildings there eventually. I don't want to spend $500,000 now and then $10 million later. It's like it was a waste of money. So I said, what's the minimum I need to do in order to make this not a parking lot? And the answer, and there is no definition of what the difference between an empty lot and a parking lot is. That's kind of the whole problem. So I said, well, if you put an impervious surface, if you put millings down, and they had plenty, Ranger Construction had lots of millings. I was like, yeah, cover the surface, make it into a real parking lot. And I didn't do that because if I had done that, then I would be here in violation of building a parking lot without a development order. So I didn't do that. And I have it now simply as a grass lot. And the county said, yeah, that's fine. Ranger Construction used it. They parked their vehicles there. Now it's a grass lot. And I said, great. I didn't make a parking lot. That was the whole point. Now I'm being, pressed for having a parking lot. And the difference between a parking lot and not a parking lot, apparent to them, is not just millings or some type of construction. To me, a marina looks like a marina when there's no boats there. Or a church looks like a church when there's no people there. A parking lot looks like a parking lot when there's no cars there. The picture that they presented as evidence, it's a vacant lot. I'm just permitted to use it for parking like everybody else in the county is. Like the car dealerships and the restaurants, the churches, for Christ's sake. Anybody who has overflow parking, if you agree with the county, is going to be susceptible to being brought here under charges, trumped up charges, under political circumstances in order to twist my arm and say, hey, we don't like what you're doing in the community. We want you to get out. That's what this is. That's just my point. Like, they're trumped up charges. I went through the process. I said, what makes it a parking lot? I avoided doing that. We started parking cars. The county used it. There was never a problem. This is an issue about RVs, not about whether I need a development order to make my parking lot. If you decide that I do have indeed an RV park, even though I don't agree, then I'm culpable, which is why I stopped doing it. But if you decide that I need, to your point earlier, that you said that I need a development order in order to park cars on an empty, that's dangerous. Because if that's the case, I'm going to use that exactly thing and can continue to press my cases against all the other 1,000 people in the community. Like, this has to be fair. Yeah, and it has to be fair. And that's, once it's fair, I will argue the point about the definition. I made the point several times about the accessory use. I can't imagine that could possibly be accepted. I'll make the same exact point about the other two cases. I think I made it about the development order. It's my motion for dismissal is still here. You were trying to help me at saying that it wasn't going to be denied, but I wanted to understand exactly under what terms. And you started going down that path, and I made my arguments. Would you please address my motion to dismiss? And I'll be quiet.
Motion to dismiss is denied. Now, do you have anything else you want to tell me?
Am I still arguing my case?
You are.
Okay, so I'm not an RV. When I was a kid, we had to go to South Carolina to buy fireworks. And some guy figured out that if he made people sign a document that says that the fireworks are to scare birds, then lo and behold, it's legal. So he found a loophole. You know, I go to the fair in Hope Sound, and they're selling raw milk. That's illegal. But if I sign a document saying it's for my animals, it's legal. The point is, I don't understand the county's intent. I just understand the rules. And when you look at it from a rules base, there are ways to do things that people don't intend. The creation of the 401k is a good example. The government didn't create it. That's some clever accountant created the most important retirement system in America by manipulating the rules. So my argument is the definition of being an RV park requires that I pay, that I charge. And if I did charge, then I wouldn't be here arguing my point because that would be illegal.
You know, let me just tell you, and I think we can maybe shorten this whole process a lot. Certainly what you're saying and what the county is saying applies to both cases. I mean, there's no question about that.
I don't
I
dispute
can
the facts.
consider them easily that way as the same issue. And I don't think I have to get as far as the RV park issue. I can limit it to the fact that there is such a thing in the code as a parking lot. There's definitions for it. There's in both Article 12 and in Section 3.3, there's a definition of what a parking lot is.
And you're making a new definition because you're saying cars parked on an empty lot is a parking lot. Up until this point, those have always been vacant lots. But
No, I'm not saying that. I'm saying if you want to use it as the primary use for parking, then you have to get a permit and be a parking lot. You can't just park vehicles on a vacant lot and call it good.
So if I have a restaurant and I own a lot next door, and I intend to use that as parking for my restaurant,
You
I would need to go through a development order?
You would get a development order for an accessory use for an immediately contiguous adjacent property. And in likelihood, that would be granted. If it was common ownership, county might require you to put a unity of title on the property, but it would be essentially where your overflow parking would go on a new parking lot permitted by the county. In your case, you've got this standalone lot that I think I understand based on the two hearings.
Mm-hmm.
I mean, your desire is to encourage development and use of the Port Salerno area.
Yes.
Maybe that's altruistic and maybe it's self-serving, or some combination of the two. That doesn't matter, but to do that, if you had come to the county and said, look, I got this nifty lot, and it's right in the middle of everything, and I want to create a parking lot.
I've been trying for a year. There's no permit. I can't go get one.
Well, yes, you can.
The only one that's ever been given is this one that you wouldn't accept into evidence. In the history of Martin County, this is the only permit that's ever issued for a parking lot. This is my overall argument. Stewart makes lots of parking lots for the citizens. Martin County doesn't just make them, they want to take them away. They want to make mine illegal. I mean, this is, might as well tie yourself to all the trees in order to stop the development.
You're almost now arguing against yourself, and
My point is, like, for example, Twisted Tuna has the history of the Twisted Tuna. Are you familiar with the area in Port Salerno?
somewhat.
Okay, so it was Finn's and then...
Objection, Your Honor. Twisted
allowed to
Tuna
argue.
is
I'm
irrelevant.
allowed to make an argument. I'm saying that they have a parking lot that they purchased after the development of the property that was a vacant lot. And they used it for the seafood festival, and its primarily purpose is parking for employees, et cetera, et cetera, et cetera. Been there for a long time. Okay? Totally accessory to the property, totally built for the property, no development order. And there never will be, because it's one of the cases that I brought that'll never get prosecuted.
All right, and you understand why that's not relevant here, because in your case, there is no, it's not, your use is not accessory to anything.
It actually is. I own the property next door, just like Twisted Tuna. I have and Paul, do I have a permitted use office on the property next door?
There is a business office that's received a business tax receipt for a commercial office immediately to the west. A very, very small lot with an old home that was converted, yes.
Okay. And do I have the permitted parking on that property for my use?
As long as you constructed the ADA space, yes, you do.
My point is that my lot is accessory, just like the Twisted Tuna's lot, to my little business. I have food trucks in that business. Sometimes I park my car there. So my commercial lot is accessory to a use that I have. They're different PCNs or different lots. Now, I could combine them and make them into a parking lot.
Again, you have not applied for a permit to do
I
it.
tried, and Lisa Wexler said I can't.
Your Honor, may I? There's a distinction between actually utilizing property on a temporary basis, kind of informally with a temporary use permit of some sort. There's also there are requirements to construct a parking lot in which you invite patrons. So meaning that parking lot would need to be built to current standards. It would need to have all the striping, the paving, the ADA requirements, the associated drainage, landscaping. So there is, in fact, an ability to apply to construct a freestanding parking lot in that area. We just haven't received that application.
The commercial boat ramp doesn't have striping, and that's a county property. The county can come here and start arguing. Sandsprit doesn't have a lot of striping in the required parking. The boats are parking in the sands. I mean, this is my point. Like, Port Salerno's been arguing about parking for 30 years. And the reason I wanted to submit these documents is because I have been pushing for parking for the past 2 years, because I don't want Port Salerno to turn into downtown Stewart. Okay, we're going to grow, and the county should have bought this property a long time ago. They should have bought my property a long time ago. And so the county's pushed back. There's a 1,000-member group against me. One of the members is here. Some people, there's actually an audience for this hearing. The point is, Martin County doesn't want parking. Martin County's never created parking. Martin County doesn't want to think about parking. Martin County can't help me. Every way I went down the road to get parking for this property, there's nothing. I go to the county boat docks. There's no striping and nothing else. It's millings on top of dirt. I could go down to Sandsprit and say the same thing. I can go to Twisted Tuna. There's 100. I can go down to the Keys, for example, imagine, and see all the different Shell Rock parking that's informal. You're going to say that the whole state needs to start calling all of these things, developments in order to get development orders? No, this is Florida. This is what you do. You put your sandals on, you walk across the Shell parking lot, you go to the bar and have a few beers. No different than what I'm doing.
Okay, I'm going to, I think, stop this and probably end it. I think I've heard enough. I mean, I've read the materials and I've heard your argument now over and over.
Well, the argument's not for you To be honest with you, it's for the circuit court. That's why I've been making the argument. So, and I can't bring new evidence. All they're going to do is just listen to this conversation, and they'll make their determination.
Well, they don't really listen to anything like that, but do you have a record of the, do you have a record of the proceeding?
Yeah, they're on YouTube.
Okay. All right. Okay. As to 163, case number, and based upon the request of the county, I am going to find that you were in violation and order you not to repeat the violation, failing which you would be subject to a repeat violation, which is an enhanced fine. So I urge you to, if you have a political argument, make it to the correct body. It is not me. All I can do is look at the code, hear the evidence, and determine whether in fact there is or was, in this case, a violation as to the case numbers endings 163. And I would tell you that that I am finding that a violation did exist regarding the use of your vacant lot,
Commercial lot.
vacant commercial lot. That's fine. It doesn't matter. It's a vacant lot.
Makes all the difference.
Well, maybe to you and maybe politically it does, but it's a vacant lot being used as a parking lot without a permit, and that alone would find you in violation. The other question, let me get to that. Sorry, this may take me a minute. Okay, the question regarding uh, 12.1.04.7.h has to do with the parking of recreational vehicles and trailers. And they're only permitted as an accessory use, and I believe that to be the case. However, and I think in their memorandum of law, you may have seen point 3, but I don't know that that really has a lot of bearing on this case, other than the fact that the parking happens to be RVs.
That's right. Only if there was anything else, it'd be okay.
Well, it wouldn't be okay, and that's what,
Well, either it
that's
is or
my
isn't.
first
Either-
point.
Either it's an accessory use and it's okay, according to your point, or it's not an accessory use and it's illegal to park at all.
It's not a permitted use in,
But I can park my truck there.
you can, as long as it's not a construction.
My point is,
truck.
if you determine that this applies, then I'm allowed to park there if I was an accessory use.
You can't park there without a permit. You have to have a permit to use that lot, whether it's temporary or permanent.
It goes the point about the accessory use cuts both ways. If you say that the parking is accessory and you're going to apply this whole accessory use thing, and the list of things that you said are permitted, then RVs are permitted.
Okay,
RVs are permitted to park there as an accessory use. I dispute that. I say I don't have an accessory use. According to that code, that doesn't apply. RVs are not permitted to park there.
okay, you're missing the point.
I think I am.
And the point is that accessory use also has to have a permit. You can't just do it.
What's my primary use?
Your primary use would have to be parking lot or something.
Right, but I can't have the primary use and the accessory use can't be the same, otherwise it's just A equals B equals C, A equals C.
You're never going to be able to park RVs there.
No, I don't disagree, I don't dispute the fact that the RV question.
Because they aren't permitted in the
That-
zone.
I never disputed the fact about the RV piece.
But that's what you've got,
Well, that's what the point of this
de
case is.
facto.
Everything in the whole world was fine until RVs started parking there.
Okay.
So that point of that, all of their arguments, though, are about everything else. If you accepted that, that's my point earlier, Your Honor. I said, if you say that I genuinely have an RV park, which is what the county genuinely believes, and a lot of people genuinely believe, when you drive by and you see all these cars there, you're like, that looks like an RV park, how can that be possible? And it's the same argument I made with the fireworks. It's possible because the county has never considered people just parking places for free on private property. If it was public, it would be illegal. If it was an accessory use, it would be illegal. If I was charging, it would be illegal. There's a long list of things that would make this illegal. But the fact that it's a private property where parking is permitted and I'm not charging, I don't fit the definition of being an RV park. I can only read. I can't go into Paul's brain.
Well, it's not Paul's brain that you have to worry about. It's actually what the county commission intended.
Which they wrote, which said I
Yeah.
had to charge.
And in fact, you have the right to rely on the common understanding and meaning of those words.
Exactly.
I don't dispute that. That's not an issue. And I don't think that the county is charging you with that.
Saying I have an RV park.
Well, they don't really say that. What they are saying is,
The second whole section says, the complaint, read the complaint. It says, you are operating an RV park without a development order. That's what the county's saying. That's what they're saying. But if you don't believe that I actually have an RV park based on the definition, then this whole case becomes very difficult to prosecute. Either I am or I am. If I am an RV park, if you say that I am, and you want to go directly against the definition, which means that I charge, this is being recorded. This will be the crux of the appeal. The point is, I'm not charging, and therefore I am not an RV park. And to your point earlier, I have the right to read the rules and try to interpret their intent. That's my right as a citizen.
Can I offer some clarification, Your Honor, considering things are getting muddied up again? There's three separate violations here. They're independent of one another and, in a way, interconnect.
Either they're independent or interconnected, one of the two.
Number one, the development order, you've already ruled on. That's sort of overarching. That's the
It
biggest, that's the overarching thing. The accessory use violation is adjacent to that, but is also stands on its own. Because even if there weren't multiple RVs parked, even if there was no RV park being intended, if there was one parked on it, there's no primary use, it cannot be there. The second prong of that violation, would you let me finish, please, sir?
I'm the argument, aren't I? I mean, I did the same thing to him, but he's a lawyer. He should understand the rules.
Hang on.
He can't make this long argument.
he understands the rules, trust me. Go ahead.
Where was it? The second prong of the accessory use is even if it was permitted, they can't be occupied. That's the crux of that violation, that we need the repeat order, that regardless of whether you get a development order for a parking lot or for a vegetable stand or for a skyscraper, an RV could be parked there then as an accessory use but cannot be occupied for any length of time. That's the gravamen of that violation.
If it was an accessory use, which there can't be because there's no primary use. That's why that whole section is null and void. If it's an accessory use, I can park cars there, but I can't sleep there. If it's not an accessory use, then it's a primary use, and Paul says that I need to have a development order. Well, then go ahead and rule and tell me it's an accessory use, and I'll use that piece of code to park cars there. I won't let them sleep overnight, because that would be illegal in an accessory use. But if you determine that the using of my lot is accessory to some imaginary primary use, then I'll apply that exact code to the use of my lot.
So let's go
For any
back.
repeat violation that they want to bring me forward.
Let's go back to the original premise that I'm standing on, and that is, you don't have a permit for anything.
I'm not doing anything.
Well, yes, you are. That's the problem.
If you say, Mr. Crowley, I believe you have an RV park based on the definition and based on the county's evidence, then I will accept your ruling and use that as the basis for my appeal. I just would wish, you went to the beginning and said you don't need to talk about anything. You went to the end and said that we'll talk about that. I would like you to answer this one question, which I would walk out of here and agree with. If you determine that I am an RV park based on the definition, please just say so. I've been asking this question for 2 hearings and nobody's been able to say. You won't say. Do you believe that I'm an RV park based on the definition of RV park
Based on what the evidence shows me,
and the definition? Do you understand?
I understand the definition.
Let's read it again. Can you read the definition one more time, please, just to be clear? The definition of an RV park? It's in my,
Does the court wish me to do this?
Please.
Okay, let me find it.
I think I've got it.
I got it someplace. Oh, I got it
Here,
over here.
I have it right here.
Okay.
All right, recreational vehicle park is a commercial use of land to provide individual spaces for 2 or more recreational vehicles on a daily basis, on a daily fee or short-term rental basis for tenancies of less than 6 consecutive months.
right. And so since I don't charge a daily fee, I cannot be, ergo, cannot be, I don't fit the definition. You know,
And-
if you did bullet points on the definition, you'd be like RV, sleeping, blah, blah, blah. And one of those things would be, if it was reversed and I had a list of requirements, you can be pretty well sure that Paul would hold me to everything. When it's in the reverse this way, 4 out of 5 is good enough. He's an RV park even though he doesn't charge. No, it isn't how it works.
And the county has argued, well, you may not charge a daily fee and you may not have short-term rentals, but you're paying somebody. Those people are paying someone, and they've asked me to accept that as the payment, even though it's not coming to you. And that's pretty iffy.
So no?
I have more difficulty with that argument than some of the others. But the fundamental principle is you now have a primary use on a vacant lot that has no permit. And I can stand on that all day, and
I agree with you.
And you're not going to win that
agree with you.
argument anywhere.
If we agree here now that my primary use is an RV park, which I've asked and I still can't get an answer, the best I got from you was maybe, just say that it is or isn't. Am I an RV park or am I not?
Can I expand, since the court has mentioned about the fee? The definition is quite plain. There is no verbiage in the definition that addresses who collects the fee. There is nothing that requires the property owner to be the one that collects the fee. It merely requires that some sort of a fee or rental arrangement. The gravamen of that, the legislative intent, is a business use of the property in order to provide parking for the recreational vehicles. The court cannot add language to statutes that the legislature did not put in there. That is a basic canon of statutory interpretation. And another basic canon is that legislatures, what they write things for a reason. They mean what they say.
I hope so.
And they didn't say in there it has to be the owner that collects the fee. It's just a business arrangement. It is undisputed from the testimony that the people who have utilized this lot for recreational vehicle purposes had to pay a fee in order to be able to access the property. It's a business arrangement. It satisfies the legislative intent of the definition of a recreational vehicle park.
And I'm sure you appreciate how tenuous that is.
Tenuous doesn't mean it doesn't exist.
Yeah, I hear what you're telling me. I think the simple answer is, I can find the violation just based on the fact that you don't have a permit.
I know, but I keep asking this simple question, the whole question of this whole case, and you won't give me an answer. I don't understand why. Am I a recreational? You're very willing to make a determination about me needing a development order, and you're very willing to make a determination about me being an accessory use. Why are we slipping and sliding past this determination about whether I'm a recreational vehicle park or not? How many times do I have to ask the same question? You've read his memorandum of law. He said the exact same thing here. Again, we've heard this argument 3 times. You've said it's tenuous at least 6 times in the past 2 hearings. Let the county lose a little bit and say, hey, Corey, you're not a recreational vehicle park. It's not going to be the end of the world.
The problem is that de facto you are. You know, they are RVs and they are parked on your property and.
That's his argument.
That's the.
That I have to somehow read intent. That if it was reversed, I would have to check off every list on Paul's things for me to develop it, but 4 out of 5 is good enough for the county. I can appreciate the intent. It looks exactly like an RV park. I don't dispute the fact that RVs are parking there. This is called the future. Uber had the same arguments. Airbnb had the same arguments. Harvest Host is having the same arguments in every small community all over town. And it starts here in code enforcement where people don't understand what we're trying to do. We're bringing positive things. I'll submit this to evidence. Harvest Host, 120 reviews in 60 days, every one of them raving. It says very clearly in my advertisement, I do not charge. And I just want to understand, you made the point. For his point, in gravitas, I don't know what it was, that somehow I'm supposed to understand the intent. I read the rules, and the rules say I have to charge, and I'm not charging.
And it-
So am I or am I not? I
And
guess.
it's not up to any of us to actually decide if we can't read it and understand exactly what the county commission meant. Doesn't mean that they don't need to fix the code, because they may.
I do.
But I can't get to RV park in this case. I just can't. I can, however, looking at 12-1-047H tell you, you can't have people sleeping overnight.
Okay. Here's my point. Either I'm an accessory, if you make me in violation of the second section with the accessory uses, then what you're saying is that I have a legal accessory use, and then this is the list of things I can do. Now, your point, though, let me finish. One of the prohibitions of RVs, they can park there, for example, as an accessory use, but they can't sleep overnight. I wouldn't be here if I knew that I was using my property as an excessive use, because I didn't know that I was in violation. But what you're saying is,
You're using it at least to a certain extent as an accessory use. I didn't realize you had the adjacent property. You are using it as an accessory use without a permit.
but we've already established that there is no primary use for the property.
Exactly.
But my point is, if you read the definition of accessory use, which I provided in the document that I gave you, I probably have it in here someplace, the accepted definition of accessory use implies primary use.
I'm just talking about the facts based on what I'm.
Just using definitions. That's not even facts here. This is just,
Okay.
Theorems.
I think I've heard enough, and I'm ready to rule in this case. So I am going to order you not to compete, and I am going to order you to pay cost in this case. I am going to, I'm going to strike the violation having to do with RV park, because I just can't get there. I don't think, based upon the way the money, if any, is paid, because I didn't see that. All I saw was the website. So the 10-1C1 violation and the 12.1.04.7.H violation stand. I'm going to get rid of the 12.6.03.2.B violation, because I just don't see it.
And just for the record, Your Honor, I would object to that.
Yes, I understand. All right. Any reason I can't apply this to the 059 case as well? Do we need the evidence? Do you want that in, either of you, both of you? Maybe you could just
Well, Your Honor, it's
stipulate and submit it.
separate matters.
I mean, if you're going to charge me $525 for each, let's just get rid of that one and I'll comply with this one and, I'm going to comply. I didn't leave here to comply. I'm going to submit it to the civic court.
All right.
But if we're going to try both cases the same, then you should at least charge me the same.
I'm afraid I don't understand the
I'm
answer.
saying what he's going to say is he's going to find me guilty of the second case and charge me another $525. So if we're going to skip that whole process, at least if we've argued $525 worth of time, or we're going to skip the whole second one, just make it at least one. That's all I'm asking. If you could ask the judge for that, to reduce the fee to $525.
I'm not being, I still don't understand. Are you agreeing to consolidate that, to not hear the
I'm
evidence in the
saying-
second case?
as long as I only have to pay one $525.
So in other words, you don't want to pay the fees in the second case?
We're going to agree that we're not going to argue it, otherwise we can spend the next 2 days arguing the second case too.
That's a county.
We can start all over again.
We've incurred the cost, basically. Well, Your Honor, the county's position is we've incurred the costs of prosecuting, investigating both these cases, including now 2 hearings.
I'll get my
So
money's
we're
worth.
not at the place where we'd be willing to waive the cost in the second matter.
Let's buckle up. I got donuts.
All right, let me just ask you, you've seen the county's request for Exhibits 1 through 64 in the 059 case. Do you have objections to those?
Oh, I'm not sure why every time I ask a question, I can't get an answer. If I can, the question was, and I asked the attorney to do it, if we can just combine the cases, we don't have to go through the list of
He
evidence.
said no.
I know, he said he's not going to recommend it. You can do what you want. You can
Well-
make my case, you can make my charges 0 if you want to.
Well,
I'm asking you now.
I'm not inclined to do that.
Well, then,
because
I'm inclined to stay here for another, to argue this whole second case,
You,
and have them present the evidence exactly the same way that they did and put it in the evidence and spend another 2 hours here. I'm just saying, if we're going to argue the cases equally, then I should just pay one fee.
you realize, of course, the costs are based upon actual cost.
They did simultaneously. That's been their whole argument, that everything's the same. There's no difference. The only difference is that I have different
Not
PCNs.
just them, but me. The more you keep me here,
Well, I'll get our
the more
money.
inclined I am to charge the
I
cost.
understand, but I'm more inclined to stay here and get my money's worth if I have to pay for it.
Oh, gotcha. Ooh, that doesn't play well. All right. If I remember correctly, the bulk of the exhibits that we looked at in the 163 case that were rejected were photographs that applied really to the 059 case.
That is correct, Your Honor.
That's correct.
Okay. And, but there were separate and, I guess, several exhibits that have to do with the original charge and then the amended charge and that sort of thing. So no, let's go ahead. Let's hear the 059 case, at least to that point, and then we can decide, we'll get the evidence, whatever is coming in or out, and then.
You rolled on the 063 case? You just said.
I did.
And so it's 525 in fees,
It's 575.
575 in fees, and I'm guilty of not having a development order and of having an accessory use. And then if I don't,
You're having used the overnight sleeping. You cannot.
so if I don't have overnight sleeping, since I'm not an RV park, the interpretation of that is I'm not going to end up back in here.
Incorrect,
Give me the
Your
You
Honor.
need a permit.
Right, but I'm saying, there's no RVs parked there, but if I park my truck, am I going to come back here and,
I don't know. You have to talk to the county about that.
I mean, I'm asking, we're doing it now, it's like, would that be the violation if they decided to, I mean, I told you I'm a political figure and, do I need to hire security? I'm going to be dragged in here again, it's like a mini Donald Trump.
All right. All right.
Not
Let-
my job.
I-
My job
I-
is
I
to
can-
tell you whether you're in violation.
I can answer that. It's a vacant land. There is no parking of any vehicle allowed on vacant land at any time.
Because I don't have a permit. But if it's an accessory use, which you've argued successfully, then as an accessory use, I'm allowed to park and store things there. You're actually expanding the use of my property.
Not without a permit.
No, I can, as an accessory use.
No.
Well, I don't need I don't need to go to the county to get a permit to park an RV next to my house. Are you kidding me?
Your house is not there.
But you're arguing that one is because the second section of your section says I can't park cars there because of an accessory use. This is where I'm losing my mind.
Actually, I think we're done with the 163 case.
Okay, we'll make the same argument again.
Have a seat,
I'll do a better job the second time after.
and we're gonna hear the 059 case. All right.
So,
Hang on just a second. Okay, let's see.
One question. Are all of these hearings, I don't see the person taking pictures in this hearing, are they all recorded? This one's being recorded as well, and will be available to the public?
Being televised, isn't it?
Oh,
Being televised live.
Correct.
Televised live.
Okay, good. I just want to make certain, because last time there was a cameraman here, but I guess he was from WPTV. Okay, so,
No idea who he was.
all right.
Okay, so just to tidy things up, this is still back on the 163 case. Based upon the evidence and the testimony that I've heard, I am going to find that two violations as charged do exist on the property, those being 10.1.C.1 for failure to have any permit for the use of the land, and 12.1.04.7.H, which requires that you cannot have overnight sleeping, which you have had in the past. This is in order not to repeat. The county having found that you came into compliance on or before this hearing, and the gravamen of that is that if you later violate the code sections that have been charged, then an administrative fine of up to $5,000 per day can accrue. All right, I am also going to award costs in the amount of $575 to be paid to the county at the conclusion of the hearing, and it is so ordered. And that's,
You could just have an application on that for the sake of clarity, Your Honor, and semantics. The 10.1C, it's not technically a permit, it's a development order. I think some of the confusion was permits refer to building permits. The development order is a separate, you need the development order before you can go and get a permit.
yeah, and I used it colloquially, but Mr. Tui is correct. It's a development order, it's a zoning issue, really, the use of the land and how it's used. All right. Okay. Now, this is case number ENF 2024-01-0059. The respondent is Capital C, Inc. And let's see, the parties are all the same. Mr. Crowley is here on behalf of the corporation, and county staff is here on behalf of the county. And Officer Counsel, are you going to testify?
Yes, sir.
All right, whenever you're ready.
My name is Chris Counselor. I've been sworn in. I am a code compliance investigator for Martin County. The respondent, Capital C, Inc. representative, is present. This case concerns the property, which is a vacant, unimproved lot located next to 4878 Southeast Commerce Avenue within Stuart, Florida, located within Martin County. This case was not generated from an anonymous complaint. According to the official records of the property appraiser of Martin County, the property owner is Capital C, Inc. A copy of the property appraiser's record of ownership is County Exhibit 1.
Okay.
And just to clarify, use of the property is vacant commercial. On January 2nd, 2024, I responded to a complaint of camping on a vacant lot. I inspected the property. At the time, I observed multiple RVs camped on the vacant unimproved lot. At the time I photographed the property, the photographs accurately show what I saw then and marked as County Exhibits 2, 3, 4, 5, 6, and 7. So, County Exhibit 2. From January 2nd. Exhibit 3. Different view showing multiple RVs. County Exhibit 4 is the back of the first RV that was in the last picture. So basically this RV here, the blue and white one, this is the tag on it. County Exhibit 5 is the tag of the gray one, which going back to this picture would be this camper here. This gray one here. And then County Exhibit 6 is the third tag referring to in the far away, this camper here.
If I could just interrupt you, I could ask the witness a question. The Officer Counselor, considering the objection that was raised in the first case as to location, were these pictures all taken on the subject property of case ending in 0059?
Yes.
Are all of the photos that are in your presentation showing vehicles, at least some of which are parked on case 0059?
That is correct.
Thank you. Continue, please.
So that's County Exhibit 6 on the tag. County Exhibit 7 is the ad advertising as the ad permits self-contained campers for primitive camping on the lots. Basically, what we're showing here, he provided aerial of lots 9, 10, 11, and 12 is where these RVs are currently located on January 2nd. And then Exhibit 8 is a advertisement for camping that was submitted with the complaint. That's County Exhibit 8. Okay, based upon the investigation, I issued a notice of violation to Capital C, Inc. on January 3rd, 2024, marked as County Exhibit 9. In that notice of violation, I had cited Section 3.11 permitted uses and Section 3.201.2.c.2.h for accessory uses. In the notice of violation, the respondent was given until January 8th to correct the violation and was informed of the need to contact Martin County Code Enforcement upon doing so. Due to the nature of the violation, and a notice of hearing was also issued by certified mail on January 3rd, 2024, which is marked as County Exhibit 10. On January 12th, 2024, Code Enforcement had a meeting with county legal staff, CRA, and growth management, and to review the details of the case and the permitted uses for a vacant lot and what codes were appropriate based on the location and nature of the violations. Based upon that meeting, an amended notice of violation and an amended notice of hearing were sent to Capital C, Inc. on January 25th, 2024, marked as County Exhibits 11 and 12. This will be Exhibit 11, the amended NOV, where we updated to use the CRA codes and we added the requirement for a land development order. My signature. With a compliance date of February 16th. And this would be the amended and notice to appear for the February 21st, 2024 hearing with my signature and the updated codes.
Okay.
In the notice, I cited the following Martin County codes. Section 10.1C1, development order required, and orders required for any development of a property over a half acre. Section 12.6.03.2B, permitted uses. A campground is not a permitted use of a property per CRA regulations. And Section 12.1.047H, using RVs for living purposes is not permitted on a property within the CRA. And the notice of violation, the respondent was given until February 16th to correct the violation and was informed of the need to contact Martin County Code Enforcement upon doing so. The return receipt was not received, so on February 9th, 2024, I posted the property. A photo of the posting and the affidavit of posting are marked as County Exhibits 13 and 14. That's a picture of my posting of the property. County Exhibit 14 is an affidavit of posting. Oops. There has been email correspondence between the owner and the code enforcement to discuss the violations to what needed to be done to correct the violations. I and county staff have inspected the property multiple times in February and March to show that some RVs have camped at the property for numerous nights. Those photos are marked as County Exhibits 15 through 52. So basically, I'll go through date by date. January 17th, RVs on the property. A second shot, RVs on the property being camped. January 17th, RVs being camped in. January 18th, RVs being camped in. 19th, the pop-up trailer was there for multiple days. Other photo of January 18th. January 19th, multiple campers. Again, January 19th. January 23rd, These two RVs spent multiple days on the property. That was January 22nd. January 22nd, multiple, different angle. January 22nd, multiple angle. January 23rd, same camper is located in the same spot on January 23rd as January 22nd. January 23rd. January 23rd. January 24th. RVs have now been there multiple days. January 24th, just showing that the same campers are located in the same spot for multiple days. At the other end of the property, January 25th, campers there for multiple days. January 25th, same campers, multiple days. January 25th, campers there now for multiple days. Go to January 26th, new RV. February 1st, multiple RVs. Again, the pop-up camper, I'm going to show that that one itself had been there multiple days. February 1st. February 1st. February 5th, Exhibit 39, pop-up trailer is there. This camper's still there. Exhibit 40, February 5th. Exhibit 41, February 5th, different angle. February 9th, multiple trailers. This one in the foreground will be showing that it was there for multiple days. February 9th. February 9th. February 9th. February 12th, camper still occupying the same spot. So been there multiple days since February 9th to February 12th. February 12th. February 16th, camper is now there, also still located in the same spot. February 16th. Exhibit 50 is February 19th, camper is still there. Exhibit 51, February 19th, just a different angle. And Exhibit 52, February 19th. That brings it, so the case was continued until a special magistrate hearing to be held on March 13th, 2024. On March 6, 2024, a meeting was held with the respondent, with code enforcement, the building official, and the growth management director. A stipulation agreement was offered, but an agreement could not be met. Exhibit 53 is an aerial photo showing the condition of the property in 2022 prior to the purchase of the property, basically showing that it was a vacant, unimproved lot. Exhibit 54 and 55 are emails from the respondent discussing the violations and reviews that he had received from campers that have camped on the property on the vacant, unimproved lot. So 54 is email correspondence between the respondent and the county. Exhibit 55 is another email, basically where the respondent shared a review from one of his campers at the property. Exhibit 56, 57, 58, 59, 60, 61, 62, and 63 are photos dated from February 20th and 26th, March 1st, March 4th, and March 5th, showing RVs remain on the vacant, unimproved lot, some for multiple days. So Exhibit 56, this is, again, the camper that was there from previous pictures from February 19th. February 23rd. February 26th. This particular RV is still there, multiple days. February 27th, now there for multiple days. Exhibit 60 is now March 1st. This particular camper is still there. We have a truck now being parked there and a pull-behind trailer. Exhibit 61, camper, showing camping use because basically the gentleman was there long enough to grill outside. Exhibit 62, this particular RV has now been there multiple days. And Exhibit 63. I request that all county's exhibits be received in evidence based upon testimony and evidence.
Oh, Chris,
Oh, sorry.
just at that, we'd ask at this point that the exhibits be entered into evidence.
All right, any objection to any of those exhibits?
Oh, and just to clarify then, Exhibit 64 would be the hard copy showing a picture from March 12, 2024, showing that the vacant unimproved lot was clear of any RVs or parking in general.
All right, so 1 through 64.
Correct, sir.
Objection?
Just the stipulation is, would you accept that these pictures represent storage of recreational vehicles in addition to potentially sleeping in them? But would you-
Objection, that requires a conclusion from the witness. It's up to
Have
the
100
court to
pictures?
determine what the evidence shows.
Does it look like storing? Could I make the argument that I'm storing things there with all of those things? My point is, does your evidence support an argument that I'm storing things? Would you agree with that? Would you agree that your argument says I'm storing things?
Objection.
I'm just asking, they're presenting the pictures as saying they're somehow overnight camping, and I'm asking if the same exact pictures, which I think are accurate, represent storing things. I'm asking if they possibly could happen. Because I'm going to use the storage
I
as,
think you can make that argument. However, let me ask too, because I'm curious, did you see people in and around those RVs?
Yes, sir.
Okay.
Because like I said, I point out in the pictures, there was grills being outside, people in chairs. The extensions on the RVs were outside with the curtains drawn, with people being inside.
So do you believe the use was more than just storage?
I do believe that the usage was more than just storage.
could it be storage?
Well, again, you can argue that. That's an argument.
Saying, make that point about the photos.
Okay.
I support the photos, but
All right, so without objection, I am going to accept into evidence the exhibits 1 through 64 in this case.
Yes, sir.
And, all right. And go ahead and finish.
Okay. I'd call Paul Schilling at this point. I would ask if the court would take judicial notice of the qualifications specified in the last case, avoid putting him on the record and qualify him as an expert witness
So noted.
for land development.
So noted, Mr. Schilling qualifies as an expert.
Okay. So basically, Mr. Schilling, basically the same questions. What is your current position?
No need,
Oh, yeah, that's right. I'm sorry. Jeez, I just said,
no need.
I'm getting more. All right. Mr. Schilling, you're familiar with the property that's the subject of this case?
Yes, I am.
All right. And that property is vacant land?
Yes.
Okay. And is the parking of vehicles of any kind on vacant land permitted without a development order?
Not without a development order, no.
Okay. And to your knowledge, has a development order been issued for this parcel?
No development order has been issued on this property.
To your knowledge, has an application for a development order ever been issued on this property?
No.
Okay. An accessory use of property under the code requires a primary use. Can you expand on what a primary use of the property would consist of?
A primary use is the permitted use, which the accessory has to be as well. But the principal or primary use, and I would use an example, would be a restaurant as the primary use, and then the parking lot as ancillary and accessory to that use.
So if there was a restaurant that, that had multiple people and they had an accessory lot next door,
Yes.
that would be an accessory use to that primary.
Correct. Assuming it had a valid development order, yes.
The primary had a valid development order,
Yes.
yes. And that is, and that sort of use is based on the use that the primary makes, correct?
Correct.
So if you have a primary use that doesn't require large numbers of people to access it, then an accessory use as a parking lot really wouldn't apply.
Correct.
And I'm not going to ask.
what did he say? I don't even know. I mean, he talked for 5 minutes. I didn't even.
I'm sorry. I didn't realize you were bounding up to,
I listened to him, but I still can't understand what he said. He said if you had a primary use, is this an accessory use? I do have a primary use next door, so in his argument, it felt like I was like, okay, great, I can be a parking lot. And then at the end, he said, well, unless that business is small and doesn't need parking, and I'm like, you're the lawyer. We expect you to be straightforward with the facts. I'm being straightforward with the facts with the magistrate, and you're trying to muddle them. I admit that there's overnight parking. I admit that I admit all these things. But don't, because you understand the law, don't try to twist it, please.
I don't know that you get to have that conversation with Mr. Tui. Let me just tell you, Mr. Tui's job is to present the case in the best light possible for the county. Your job is to present your case in the best light for yourself. And frankly, I think you've tried to do that and perhaps done it fairly well. You've pointed out at least one inference regarding the recreational vehicle park. And I tend to agree that it's too tenuous to say that in fact, in this case or the one prior, that those people have paid money.
I agree, but I couldn't pay a lawyer $800 an hour to do tenuous things. They would
Well-
say, Corey, I'm not going to do tenuousness.
All right.
Yet the county can pay someone to be tenuous.
Okay. Do you have any other questions of Mr. Schilling?
Let me think. Mr. Schilling, are you familiar with the accessory use property that the respondent refers to?
I'm not sure what he's referring to.
Well, are you familiar with the permitted use on that property?
The coffee shop, the proposed
The
coffee.
property next door, yes. Okay.
Okay.
Okay, yes, there is that was an old residence that was converted not all that long ago by the applicant into a business office.
Business office,
I think
not a
it's
retail location.
500 square feet or somewhere thereabouts. Correct.
For a private business uses, not for public access.
Actually, I think it's the office for the Salerno Port Authority.
Downtown.
So it's
I'm
a, so it's a 500 square foot private office building.
660.
Okay, 6, I was close.
No further questions.
Well, I have food trucks in that property, which the reason I have the office in the first place, and the reason I went through the BTR was so I can put food trucks on the property. So the argument he's trying to make, again, tenuously, is I don't have a need for parking. How many people want to come and eat, genuine Guatemalan tacos? Lots. My point is, my property has a primary use and a need for parking, regardless of Mr. Toomey's.
Understand, though, that's not necessarily relevant.
He's making it relevant because they're making the case that I have an accessory use, and Mr. Schilling said under oath that if I had a primary use, then the parking lot would be accessory, and I wouldn't need to be in a development hearing.
No, that's not what he said. And that's not.
My point is, let's stop the development hearing thing.
And I've read
That at
the-
least my parking would be accessory, right? We can agree to that?
No.
Either we do or we don't. The same argument we had last time.
No. You're asking the wrong person. What I'm saying to you is, listen again, okay? Because this is critical to everybody's understanding of what is happening in this hearing. You have people parked on a vacant lot without any development order.
Not according to Section 3. If you keep on going to the first section, we're not talking about that. We're talking about the second part. I'm saying,
I can talk
The
about
way-
anything I like. I'm running
My point
the
is,
hearing.
the way to defeat
I-
me is to not say anything to me. And the reason I'm trying to separate the issues is because they are separate. But when I ask about accessory use and you talk about development order, let's at least talk about the same thing. They're making the case, and the reason I'm making this point is because he asked Mr. Schilling his expert opinion about accessory use. And the case has been made in the second violation that, in fact, my parking is an accessory use. And my point is, either the county says that my parking is an accessory use, in which case overnight sleeping would not be allowed. Or the county says it is not an accessory use, and this whole section is garbage. So one of the two things have to happen. It is accessory, or it is an accessory. And I'm okay with either. I just want a determination.
Understand that you could have an accessory use without a permit, and that's what you got, without a development order.
Okay, but am I?
You have people parking on a lot that's adjacent to other
Is it accessory?
land that you
So
own.
You're saying it's accessory.
It doesn't qualify because you don't have a permit. It's a vacant lot.
You just said under oath that if I had a primary use next door, that Let's separate the development order piece. You keep on bringing that, we're looking at this code here.
Can't.
You can. You did it with the RV parking.
I did not.
You did. You looked at the definition. That's what we're trying to do here. We're trying to focus on the definition of accessory use. This is where the truth comes out on my side rather than all this intent. But just follow me through.
Okay.
Follow me through. They're making the case that my use is accessory. And my point is, I'm okay with either. If you tell me that section 12.1.04.7.h applies because, Mr. Crowley, your parking is an accessory use to some other thing. If you say that to me, I'll say fine. But if you do say that to me, what it means is I am an accessory use, and then I can start doing this. I can start storing, parking, including not only boat trailers, camping trailers. I can start doing all of these things. But they brought this case against me, not saying I was doing the storage, which is on my point about the photos, is that I was having people sleep. The only thing I can't do in here, if you read this code entirely, says, provided they do not sleep or live another occupancy. My point is, if you apply this, then it implies that I'm permitted to do all of these things, which I'm not actually permitted to do. In the CRA code, I'm not. So, I mean, how can you say I'm accessory? Now, if I had a house in the CRA, I would be permitted to do these things. My point is, either I'm in violation of storing things, or I'm in violation of people sleeping, and that can't be both. And my argument is, I don't have a primary use, therefore I cannot have an accessory use. If your argument is you have some primary use, which I don't know what it is, and I am an accessory use, ergo, I am prohibited from having people sleep in these things that I store, I accept that. What it means, though, when I walk out of here, is I'm able to then make this into a storage unit. I can store things on this property.
Yeah, no.
Or I'm not an accessory use, and you throw this section out.
Actually, no. No, I hear your argument.
Permitted, it says, if you say I'm an accessory use, it says,
Okay.
I'm
I'm not going to
permitted to
argue with
store-
you. I'm not going to argue with you. That's not my job, and it's not your job to argue with me.
I'm
Okay?
arguing with them, I'm just
All right.
getting frustrated
All right.
because
Sit
we're trying to
down.
slice this into pieces so that we can all digest it.
Okay. Unless you have anything further, I'm ready to rule.
Well, we haven't got to the development piece yet. I have lots to argue, yeah, we got a lot to talk about. We're talking about this accessory piece, this 12.107.4. I'm asking a specific question. For the second time, it took me 10 minutes for you to say, let's strike the RV section. You could have just said, let's rule on it. We're doing the same thing for a second time. I would just like to ask you, am I or am I not an accessory use?
De facto, it could be.
Am I or am I?
I don't have to rule that way.
It is.
I just have to
You
find
have to
out-
rule because if I'm not accessory,
Oh,
then I don't.
Geez.
Why won't
Look.
you rule? That's the key to the whole thing.
My ruling is that you are not permitted to have people sleeping in those units.
Why? Because you said I wasn't an RV park.
You have
under
no.
Under what rule do you make that rule?
You have no permit
Under what rule, though? Under
or-
what code? Can't they sleep there? Where?
under, they can't sleep
They sleep at the
there
fairgrounds.
under
They sleep at the-
12.1.04.7.h.
Okay, so you're saying I am parking, you're saying that this section applies.
De facto.
Because somehow I'm an accessory use.
De facto.
No.
You have no permit to be an
You
accessory.
can't be
use.
both a primary use and accessory use. The reason you can't, my point is, if I'm not an accessory use because I have no primary use, then all of the rules about accessory uses don't apply. It's like saying you're a restaurant, the rules for restaurants apply, and I'm really a car shop. Either I am or I'm not an accessory use. All I'm asking is, am I or am I not? And you're saying you are. Is that
Your-
correct?
Your Honor, may I, if it helps the court? There is not an ability to live in RVs or trailers parked on any property in the county other than designated recreational vehicle parks and campgrounds. So aside from the argument that the applicant is making, there is no ability to simply park here and stay in that vehicle overnight or for any purpose or at any given time without the appropriate development order.
And the fairgrounds has that?
And irrelevant what the fairground says. And Your Honor, if I could expound on that, it's not just the occupancy, the mere fact of the things being parked there. It's a permitted use as an accessory. Respondent seems to be confusing the fact that there has to be a primary use on the property before any accessory
I
use can be
agree.
made.
So strike 12.104.7H for Christ.
No.
Because if I don't have an accessory use, he just made the point for me.
You have it backwards,
whole
so you
section
need the
does-
primary before the accessory.
I really have heard enough. Thank you so much. I really appreciate this. Based upon the evidence and the testimony, both yours and the county's, I'm going to find that violations of 10.1.c.1 and 12.1.04.7.h do appear on this property, and I'm going to order you not to repeat the violation and to pay costs in the amount of $575 to be paid to the county at the conclusion of this hearing. Understand again, just the same as the other case, if you violate the ordinance again, you are subject to a fine of up to $5,000 per day, for every day of violation. So, thank you, and
Your Honor, are you dismissing the,
I am,
the 12603?
I am,
Okay, so over objection.
over objection. Thank you. Anything else to come before us?
That's
We're
it.
adjourned.
Thanks, sir.
Thank you.
Thank you.